Good evening and welcome to the Guildford Chambers Children's Public Law Update 2021. I'm Suzanne Kelly and my co-host this evening is Dominic Gillen. Tonight we're going to be talking to you about some recent developments in some case law and the topics that we will be looking at. I will be looking at the legal test for the discharge of a care order and leave for discharge of a special guardianship order, followed by some fact-finding hearing cases. And then Dominic will speak to you about deprivation of liberty orders, inherent jurisdiction and joinder of foster carers. So turning first to the discharge of a care order and the legal test. The leading case in this currently is Re TT. It's Children Discharge of a Care Order 2021. And what this case does, this case sets out the tests to be applied on an application to discharge a care order. And in addition, it considers the relevance of attachment theory in welfare evaluations. I'm not going to be discussing the attachment theory in this topic tonight. Mostyn's approach to these issues in the recent case, 2018 case of GM and Carmarthenshire County Council was overruled. In this particular case, Peter Jackson granted the mother leave to appeal, not because of a prospect of success, but because it gave an opportunity to consider the correctness of the approach to the discharge set out by Mostyn in GM, to which the judge had made reference. And having reviewed the interrelation of the Children Act 1989, the Act, and the Human Rights Act 1998, in particular paragraphs 19 to 23, and the previous decisions of the Court of Appeal in the matters of Re S and Re C, and previous case law, Peter Jackson summarised the approach required when a court is considering an application to discharge a care order, saying that the legal principles are clear. And the legal principles that he clearly set out are that the decision must be based in accordance with Section 1 of the Act, by which the child's welfare is the court's paramount consideration. Interference with convention rights must be proportionate and necessary. The applicant must make out a case for the discharge of the care order by bringing forward evidence to show that this would be in the interest of the child. However, the welfare evaluation is made at the time of the decision. The Section 31(2) threshold applicable to the making of a care order is of no relevance to an application for its discharge. The local authority does not have to reprove the threshold, nor does the applicant have to prove that it no longer applies. Next slide, thank you. The fundamental test to be applied to an application under Section 39 and to other applications under the Act is the welfare principle, and not a test of necessity or some other test. The attempt in this and other cases to shift the focus away from welfare is neither helpful nor necessary. A proper welfare analysis and proportionality cross-check is a dependable bulwark against any tendency towards social engineering. The court also reinforced the principle from Re DAM Children 2018 at paragraph 42.5 that the aphorism "nothing else will do" applies to cases involving a plan for adoption and not to applications for care orders, and said the same applied to discharge applications. Moving on for the legal test for leave to apply to discharge a special guardianship order. The case we're looking at this evening is Re M, Special Guardianship Order Leave to Apply to Discharge 2021. This case approved the two-stage approach taken in Warwickshire, that there must be a change in circumstances, and whilst this is necessary, it is not in itself sufficient. There is also a need to weigh the welfare of the child with the prospects of success. In Re M, it said that the leave turns on the construction of Section 14D5 of the Children Act 1989, the 1989 Act, in the context of an appreciation of the nature and effect of special guardianship orders. The appeal also concerned the circumstances in which an application for a child arrangements order can summarily be dismissed. I will not be looking at those circumstances this evening. The proceedings concerned C, a boy then aged 9. In October 2016, following a breakdown in his mother's mental health, C, then aged 4.5, moved to live with his maternal grandmother and her partner, the grandparents. The mother was assessed by a consultant psychiatrist, Dr. Ratnam, as having an emotionally unstable personality disorder and as needing long-term therapy. It was suggested that she work with the Complex Needs Service over 12 to 18 months to assist her in managing her condition. However, at the time of the assessment in May 2017, the mother did not recognise the need for a referral. The care proceedings, however, ended in July 2017 with a special guardianship order and a carefully worded threshold document. The outcome was that a special guardianship was made to the grandparents' favour without opposition from the mother. It was accompanied by a written agreement signed by the grandparents, the mother, Mr. D, and approved by the local authority in the court. The agreement, which describes itself as underpinning the special guardianship order, spelled out how decisions for C would be taken and how information would be exchanged. In February of 2020, the mother applied for leave to make an application to discharge the special guardianship order with a view to C returning to her care. In giving judgment, the court considered the law in respect of special guardianship orders, commenting at paragraph 18 that the purpose of a special guardianship order is therefore to achieve permanence for the child. The term permanence has a special meaning in care planning as defined in the Children Act 1989 Guidance and Regulations Volume 2, Care Planning, Placement and Case Review 2015. Permanence is the long-term plan for the child's upbringing and provides an underpinning framework for all social work with children and their families, from family support through to adoption. The objective of planning for permanence is therefore to ensure that children have a secure, stable and loving family to support them through childhood and beyond, and to give them a sense of security, continuity, commitment, identity and belonging. In terms of discharge or variation of a special guardianship order, the court turned to Section 14D of the Act, which was concerned with the manner in which special guardianship orders, unlike adoption orders, can be varied or discharged. Section 1 sets out who is able to make an application for variation or discharge of a special guardianship order. And Section 1A is the special guardian, or any of them if there are more than one, any parent or guardian of the child concerned, any individual who is named in a child arrangements order as a person with whom the child is to live, any individual not falling within any of the paragraphs A to C, who has or immediately before the making of the special guardianship order had parental responsibility for the child himself, or finally a local authority designated in a care order with respect to the child. Section 3 sets out who requires the leave of the court before such an application can be made as follows: the child, any parent or guardian of the child, any step parent who has acquired parental responsibility and who has not lost the same, and any person named in subsection 1D who had parental responsibility immediately prior to the making of the special guardianship order, but who no longer has that parental responsibility now. Subsection 5 of Section 5 of the 1989 Act says the court may not grant leave to a person falling within subsection 3, B, C or D unless it is satisfied that there has been a significant change in circumstances since the making of the special guardianship order. Accordingly, a parent seeking to discharge an SGO requires a leave of the court under subsection 3b, which can only be given if the court is satisfied under subsection 5 that there has been a significant change in circumstances since the making of the order. In Re G 2010, it was said that when considering such an application for leave to apply to discharge a special guardianship order, the court should follow the two-stage approach applicable to applications for leave to revoke a placement order set out in M and Warwickshire County Council 2008. That case established that a change in circumstances is necessary, but not sufficient for leave to be granted on its own, and that if there has been a change of circumstances, the court also has to make an evaluation in which the welfare of the child and the prospects of success should both be weighed. In this case, the court agreed that the two-stage approach taken in Warwickshire was the appropriate structure for a decision about granting leave under section 14d(5). The court grappled with the difficult decision and wording and the difference in statute wording where Parliament, in respect of leave to apply for revocation of a placement order, have required that the court should be satisfied of a change in circumstances, where in relation to an application for leave to apply to discharge a special guardianship order, Parliament, by subsection 14d(5) of the Act, has required the court to be satisfied that there's been a significant change. Much thought and submissions were made in respect of the meaning of the wording of a significant change, and the court concluded that the requirement under section 14d(5) for a change in circumstances to be significant means exactly what it says, and to that extent only, it did not follow the recommendations in Re G. Turning to the second stage, at paragraph 29, the court said, what has to be shown in a case under section 24(3) is broadly a real prospect of success. In my view, the same approach should be taken in a case under section 14d(5). And likewise, echoing relevant elements of the guidance given in the adoption context in Re BS, the degree of any change in circumstances is likely to be intertwined with the prospect of success, and the greater the prospects of success, the more cogent the welfare arguments must be if leave is to be refused. And at paragraph 30, the court said, further, following the approach taken under section 24(3) in Warwickshire, the welfare of the child is an important but not paramount factor at the second stage. For no obvious good reason, the position is different under section 47(5), and for that see Re P 2007. It must be remembered that at this stage, the assessment concerns the effect on the child's welfare of the application to discharge the special guardianship order being heard or not. The question of whether it is in the child's interests for the SGO to be discharged only arises if leave is granted, at which point welfare is undoubtedly paramount. The power conferred by section 14d(5) is to be exercised firmly within the context of the overall statutory scheme governing special guardianship orders, noting in particular that the door to reunification with a parent is not locked under a special guardianship order, but the intention of legislation is that the door will remain closed unless the court allows it to be opened to the extent of granting leave for an application to discharge. Turning now to fact-finding, the first topic that I wish to look at this evening in terms of that is the court's ability to limit, withdraw or dismiss a local authority's factual case prior to conclusion of the evidence. And the question asked is, does the court have the jurisdiction to limit a local authority's factual case at the conclusion of the evidence called by the local authority or partway through the hearing? And this was considered in B care proceedings mid-trial dismissal and withdrawal of allegations 2021. And this provides a useful review of recent authorities on the point. The court determined that there is indeed such a jurisdiction. In coming to that conclusion, the court considered the following. Sir Mark Headley in AA and 25 others 2019 had also considered the issue and came to the same conclusion. In his judgment at paragraphs 36 and 37, he said that the correct modern approach was to be found in the decision of Mumby and Re T G care proceedings 2013, where in paragraphs 24 to 28, Mumby says this. In this connection, that is to say, dealing with evidence, I venture to repeat what I recently said in Re C, Children Residence Order application being dismissed at a fact-finding stage 2002. These are not ordinary civil proceedings. They are family proceedings where it is fundamental that the judge has an essentially inquisitorial role, his duty being to further the welfare of the children, which is by statute his paramount consideration. It has long been recognised, and authority need not be quoted for this proposition, that for this reason a judge exercising the family jurisdiction has a much broader discretion than he would in the civil jurisdiction to determine the way in which an application should be pursued. In an appropriate case, he can summarily dismiss the application as being, if not groundless, lacking enough merit to justify pursuing the matter. He may determine that the matter is one to be dealt with on the basis of written evidence and oral submissions, without any need for oral evidence. He may decide to hear the evidence of the applicant and then take stock of where the matter stands at the end of the evidence. The judge in such a situation will always be concerned to ask himself, is there some solid reason in the interests of the children why I should embark upon, or having embarked upon, why I should continue exploring the matters which one or other of the parents seeks to raise? Sir Mark Headley was at pains to point out that the principle of no case to answer has no proper place in family proceedings, but that did not detract from the family court's case management powers to intervene. It would be a power used in the most exceptional of circumstances, and examples included medical evidence changing to a benign conclusion that required no explanation from the parents, or a vendetta being pursued against the parents that was an abuse of process. In a local authority in W and others, application for summary dismissal of findings 2020, MacDonald noted the decision in the Court of Appeal in Re H and L, Children's Summary Dismissal of Care Proceedings in 2019, and decided that it remains to be seen whether Re AA can survive that decision. Re HL concerned the dismissal of proceedings at the case management stage prior to the local authority calling any evidence at a fact-finding hearing. In H&L, the case management provisions were described as a self-contained code with detailed provisions that make it unlikely that recourse to the more general procedural provisions will be necessary. Mr. Howe QC decided that H&L had not undermined ANA and others, and there was jurisdiction to dismiss care proceedings. However, in this particular case, the court did not go on to dismiss the local authority's case without hearing first all of the available evidence. Very briefly, this evening, I'm going to touch on Scott schedules, and the cases that I am looking at tonight arise out of private law proceedings. They're relevant to the public law update, given some of the guidance that came out of those in respect of fact-finding hearings, and judges in public law proceedings reaction to the same. The recent case of H&N and others, Domestic Abuse Finding of Fact Hearings 2021, involved a review by the Court of Appeal of the practice and procedure relating to domestic abuse in 4 cases. The appeals in these 4 cases were all heard together. They were appeals from orders made in Private Law Children Act proceedings, each of which involved allegations of domestic abuse. As well as deciding each of the appeals upon well-established legal principles, the court took the opportunity to give some guidance about a number of matters which commonly arise in the family court in such cases. The judgment, whilst wide-ranging, is relevant for the purpose of this public law update, as guidance was given in respect of Scott schedules, and public law cases often have allegations by parents against one another or a local authority seeking to rely on domestic abuse. The specific guidance that was given by the court was in relation to whether there should be a finding of fact hearing and the use of Scott schedules. The court endorsing the view of the parties and of the authors of the harm report that the time had come for there to be a move away from Scott schedules as a means of identifying issues to be tried by the family court. Scott schedules which identified specific factual incidents tied to a particular time and date are at a risk of failing to focus on the wider context and whether there has been a pattern of coercive and controlling behaviour. Not every judge has drawn the same parallels from these judgments and the guide provided. I, in practice, have had at least 3 different judges within public law proceedings with 3 different opinions in respect of the same and approaches to how they conducted fact-finding hearings. And it will be interesting to see how these judgments and guidance impact upon practice moving forward. Turning now to the last issue that I'm going to address you on this evening is the importance of adequacy of reasons for findings of fact. And the reason that I have picked this particular case to review tonight is that the facts of it chime very closely to a case that I have been involved in and for which there is a forthcoming appeal. The case concerned is YW, a Child Adequacy of Reasons 2021. And what has come out of that case is that the court has reinforced that there must be rigorous and coherent analysis before the court makes findings. The court must exercise an overview of the totality of the evidence in order to come to a conclusion. These particular proceedings concerned YW, who was taken to hospital with a large bruise and swelling over the left forehead, extending to under the right eye and behind the left ear. At the fact-finding hearing, evidence was heard from a number of parties: the parents, 3 interveners, NA, SA and SN, the mother's sister and 2 social workers. No evidence was called from the treating physicians or the court-appointed medical expert. The local authority sought a range of findings, which included the following. And you will note that there is some discrepancy in terms of the letters that are attributed to some of the interveners. Having cross-referenced very carefully the judgment, it appears to be typographical errors in the judgment itself. The local authority sought a range of findings that YW had suffered a significant facial bruising, which had a high likelihood of non-accidental injury and was inconsistent with the suggested mechanism, that the mother, NA and SA had colluded to provide misleading and false explanations of the causation of the injury. that the injury was inflicted deliberately, recklessly, or negligently by NA, SA, or SN, notably not against the mother, and that in the absence of a finding against one perpetrator, neither can be ruled out. The findings made by the judge are set out at different points in the judgment, but can be summarised as follows. 1. The mother had lost her temper with the child on the 31st of October 2019 and inflicted the injury. NA heard and saw what the mother had done and had failed to protect the child. YW sustained a significant injury to her eye on or around the 31st of October 2019 whilst in the mother's care, caused by excessive physical chastisement and loss of control. The mother failed to protect YW by not seeking medical attention for the injury sustained on the 31st of October and failed to mention this injury when the child attended hospital on the 1st of November. The allegations made by the mother against NA of sexual abuse were untrue and deliberately made up. The allegation that the mother had undergone sham marriages arranged by NA was also untrue. That NA arranged for the mother to travel to Cyprus for an illicit purpose, although the judge did not speculate further about what that purpose was. NA was keen to conceal her absence and therefore was party to the fabricated story that she was present when the injury was sustained. The mother took drugs and led a chaotic and itinerant lifestyle which failed to bring stability and security to the child. She has a history of self-harm which she concealed from the professionals. The mother and father had not been honest with professionals, lied about their relationship, and concealed or retracted information which impacted on YW's safety. The mother had a sexual relationship with NA, made false allegations against him about drugs, possessing a gun and a sham marriage, and had blackmailed him. SA was isolated and vulnerable. She had protected her own daughter, but had failed to protect YW by insisting on getting medical attention. No findings were made against SN beyond his admission that he should have checked on the children whilst he was looking after them. It's recorded that several of the parties asked the judge for clarification on her findings, and these were provided in a composite document. To many of the inquiries, the judge simply responded that she had already dealt with the matter or that no further reasons were required. The judge's findings went against the medical evidence, which had set out that it was entirely plausible and possible that the explanation provided by the mother could account for the injuries and that they were likely to be accidental. When considering the appeal, the Court of Appeal found the judgment at first instance was insufficiently reasoned. The criticisms are set out in full at paragraph 56 onwards, but include the following. The judgment lacked a clear structure, such that elements one might expect to see were absent. There was no summary of the issues or the findings that each party was seeking on the issues. There was only a partial chronology. There was no discussion section drawing together the different threads of evidence. A rigorous and coherent analysis was required before the judge arrived at her conclusions. The Court of Appeal highlighted the importance of considering the totality of the evidence and cited the following from the judgment of Dame Elizabeth Butler-Sloss in Re T at paragraph 33, where it is said that the evidence cannot be evaluated and assessed in separate compartments. A judge in these difficult cases must have regard to the relevance of each piece of evidence to the other evidence and to exercise an overview of the totality of that evidence in order to come to the conclusions of whether the case put forward by the local authority had been made out to the appropriate standard of proof. the Court of Appeal referred to comments by Macfarlane, as he was then, where it is said that what is really important is the substance of judicial analysis rather than its structure or form. But nonetheless, structure is valuable because it can help to ensure clarity of reason and analysis. In this particular case, the judge made comments as she went through the various parts of evidence and made findings in respect of the same before coming to a reasoned judgment at the end. And the Court of Appeal was critical of the judge's approach in providing this running commentary as to her views of the credibility of each of the witnesses as she went through the evidence. The court found that the judge reached conclusions on part of the evidence prior to hearing that evidence. And in particular, the court found that the judge accepted social work evidence as being fact prior to hearing from the social worker. The court found that the conclusion should have been reached after she considered the totality of evidence, all inconsistency in which the way the judge dealt with the lies of the mother as compared to the lies of the others is noted. And in this particular case, the court noted that whilst the judge gave herself the Lucas direction in respect of the lies and inconsistencies noted in the other witnesses' evidence, she did not appear to have applied this to the mother's evidence. And at paragraph 68 of the judgment, the Court of Appeal found that the issue of the mother's lies overwhelmed the judge's whole analysis and considered the judge had fallen into the same error observed and cautioned against by McClure in Re Y 2013, where at paragraph 7 he said, "I consider the case appears to have been hijacked by the issue of the mother's dishonesty. Much of the local authorities' evidence is devoted to it. The children's guardian adopts much the same perspective. It cannot be the sole issue in a case devoid of context. There was very little attention given to context in this case. No analysis appears to have been made by any of the professionals as to why the mother's particular lies created the likelihood of significant harm to these children, and what weight should reasonably be afforded to the fact of her deceit in the overall balance." The findings made by the judge as to the mother's lies and to her character and lifestyle may be relevant to her overall analysis, but she did not provide any sufficient explanation of why they led her to the conclusion that the mother had inflicted the injuries. There was also no reasoned judgment as to why the judge had departed or disregarded the expert's view. The judge was obviously impressed by the evidence of the mother's sister, MD, and accepted her account of the mother's poor parenting and lack of emotional responsiveness towards her child. It is accepted and a well-established fact that the assessment of evidence is the responsibility of the trial judge, but so is the apportionment of weight to be attached to each piece of evidence. And in this case, the judge failed to explain her reasons for apportioning weight to one piece of evidence over the other. And accordingly, the mother's appeal was therefore allowed. And I'm now going to hand over to Dominic, who will take you through the deprivation of liberty and the court's inherent jurisdiction.
I'm just now waiting for someone to say, "You're on mute, you're on mute." I want to speak very briefly about the authorization of deprivation of liberty orders for young people, an issue which regrettably comes up not infrequently in public law cases, particularly where there are older children. Crisis in the provision of secure accommodation has been an issue which practitioners have faced for some time, and one which appears to be worsening. The Court of Appeal bemoaned the situation in 2018 in the case of VT, a case which was to later go up to the Supreme Court, and we'll be looking at that in greater detail in due course, as well as in the 2020 case of B, noting that the absence of sufficient resources meant that the local authorities were frequently prevented from complying with their statutory obligations to meet the welfare needs of a cohort of vulnerable young people who are at the greatest risk of harm. And then before then, Sir James Mumby made a number of forceful observations in the 2017 case of X and referred to what he termed a well-known scandal, namely the disgraceful and utterly shaming lack of proper provision in this country of the clinical, residential, and other support services so desperately needed by the increasing numbers of children and young people afflicted with the same kind of difficulties as X is burdened with. Let's look firstly at the statutory scheme regulating deprivation of liberty orders. Under Section 22G of the Children Act, local authorities are subject to an overarching duty to ensure sufficient accommodation is available to accommodate children with different needs, and this is the sufficiency duty. Section 22C6 sets out placement options available to the local authority where the child cannot be placed with a parent or person with parental responsibility, and one such accommodation is placement in a children's home in which is registered. That's Section 22C6C. Section 22C6D allows the local authority to place a child subject to Section 22D in other arrangements which comply with any regulations made for the purposes of this section. And the term Children's Act, as defined in Section 105 of the Children Act and Section 1.2 of the 2000 Care Standards Act, is an establishment which provides care and accommodation wholly or mainly for children. Section 25 is concerned with the use of accommodation for restricting liberty, and subsection 1 says that a child who's being looked after by a local authority in England or Wales may not be placed, and if placed, may not be kept in accommodation provided for the purposes of restricting liberty, so secure accommodation, unless it appears that there's a history of absconding, likely to abscond, and if he absconds, he's likely to suffer significant harm, or that he's kept at any other description of accommodation, he's likely to injure himself or other persons. Subsection 7 says that the Secretary of State may, by regulations, provide that a child may only be placed in secure accommodation that is of a description specified in the regulations. And there's corresponding legislation applicable in Wales under the Social Services and Wellbeing Wales Act of 2014. Regulations therefore provide that a children's home must only be used as a secure accommodation if it's been approved for that purpose. That's the Children's Secure Accommodation Regulations of 1991, and where the home is registered, and that's provided for by the Care Standards Act of 2000. Moving on to the case of T, that case posed the following questions. In circumstances where insufficient places are available in registered secure children's homes, is the exercise of the inherent jurisdiction to authorize a child's placement in an unregistered secure accommodation lawful? And secondly, is a child's consent to the confinement of any relevance when determining whether to exercise the inherent jurisdiction? The facts of the case are as follows. The appellant T was a 15-year-old girl who's subject to a care order. By July 2017, when proceedings commenced, T had already been spent time living in an approved secure accommodation unit. However, in view of her particular needs, the local authority, Caerphilly County Borough Council, wished to place T in secure accommodation. Placement 1, the first accommodation found, was neither registered nor approved for use as secure accommodation. These arrangements were nonetheless sanctioned by Mr. Justice Mostyn when the matter first went before him. In due course, however, placement 1 broke down and placement 2, a registered children's home, but not one approved by the Secretary of State, was identified. Since there were no places available in registered secure children's homes, the local authority applied to the High Court for orders under its inherent jurisdiction, authorizing T's placement in non-statutory accommodation. T had in fact consented to the restrictions on her liberty in the placements sought and submitted that the orders restricting her liberty were therefore unnecessary. At the Court of Appeal, T's case was limited to the issue of her consent and the necessity for such orders. Although the Court of Appeal dismissed her appeal in October 2018, T was not granted legal aid for an application to appeal to the Supreme Court until August 2019. By the time the Supreme Court granted permission to appeal, in fact, the orders authorizing the deprivation of liberty had been discharged on application by the local authority, and in spring 2020, T turned 18. The issues before the Supreme Court were therefore academic rather than of relevance to T personally. At the Supreme Court, it was argued on behalf of T that the use of the court's inherent jurisdiction was not permissible in the circumstances because of Section 100 of the Children Act. Section 102D says that no court shall exercise the High Court's inherent jurisdiction with respect to children for the purposes of conferring on any local authority power to determine any question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. It was also predicated upon the suggestion that the inherent jurisdiction must not be used in any way as to cut across the statutory scheme of the Children Act, as it would here in breach of Section 25. And finally, the deprivation of liberty authorized under the inherent jurisdiction would fall foul of Article 5 of the ECHR, which provides that no one shall be deprived of his liberty save in accordance with the procedure prescribed by law. The Court of Appeal were unanimous in dismissing the appeal and held that the use of the inherent jurisdiction to authorize the deprivation of liberty in cases of this nature was permissible, but expressed grave concern about its use to fill a gap in childcare system caused by inadequate resources. Lady Black, whose picture is there, gave the leading judgment. The justices concluded that Section 100 of the Children Act prohibits the use of the inherent jurisdiction to confer, in particular, the power to determine any question in connection with any aspect of parental responsibility for a child on a local authority. That, of course, reflected the requirement of the Children Act that the local authority which needs such a power must obtain a care order. It does not, however, prevent recourse to the inherent jurisdiction in a case such as this, where the local authority already had PR by virtue of a care order. Lady Black said that it must be borne in mind that Parliament made it very clear that it was not intended that the inherent jurisdiction should be entirely unavailable to the local authorities, and that it was appreciated that there could be cases in which it would be necessary to have recourse to it because there was reason to believe that the child would otherwise be likely to suffer significant harm. Subsequently, the Supreme Court concluded that Section 100 was not applicable since the local authority here already had parental responsibility for T by virtue of the care order in its favor. The argument that the placements fell foul of Section 25 in that the placements concerned were not registered and that the people who carried on or managed it were guilty of an offence if used in the manner sought by the local authority also did not find favour of the Supreme Court. Now, you'll recall that Section 25 of the Act read alongside the Children's Secure Accommodation Regulations of 1991 and the Care Standards Act of 2000 provides that a child may not be placed and its place may not be kept in accommodation provided for the purposes of restricting liberty unless the property is approved or and registered. The justices pointed out that it was clear from other cases that the inherent jurisdiction was already being used to authorize the placement of children in accommodation which should be registered as a children's home, but was not so registered. This was underlined by the practice guidance dated the 12th of November 2019, issued by the President, where instead of prohibiting such practices, made provision that where a court authorizes placement in an unregistered unit, steps are immediately taken by those operating the unit to apply for registration. That practice guidance essentially acknowledges this practice and tries to put in place safeguards. Lady Black went on to say, if the local authority cannot apply for an order under Section 25 because there is no Section 25 compliant secure accommodation available, I would accept that the inherent jurisdiction can and will have to be used to fill that gap. Ultimately, however, I recognize that there are cases in which there is absolutely no alternative and where the child or someone else is likely to come to grave harm if the court does not act. As to the suggestion that the use of the inherent jurisdiction fell foul of Article 5, the court said that once a court order authorizing a deprivation of liberty has been made with the appropriate safeguards, it cannot be said that such deprivation is not in accordance with domestic law for the purposes of Article 5. Turning to the part of the appeal in relation to consent, at the High Court, Mr. Justice Mostyn's initial finding was that T's consent was not an enduring consent, and at the subsequent hearing, again before him, following on from the breakdown of the first placement, he found that while T's consent was apparently authentic, it was not genuinely expressed. At the Court of Appeal, this assessment was not interfered with, and so there was no basis for holding that the judge was wrong to authorize restriction of liberty in T's case. Lady Black observed that even leaving to one side difficult issues about the pressures that circumstances may place on a child to consent to a proposed arrangement, an apparently balanced and free decision made by a child may be quickly revised and/or reversed. She acknowledged, however, that any consent on the part of the child will form part of the circumstances that the court must evaluate in considering an application for an order authorizing a local authority to restrict a child's liberty. She was not, however, prepared to be drawn on the implications of such for any particular case, concluding that it must depend on the facts. The case of Tamside, MBC and AM went before Mr. Justice McDonnell, following on from the Re-T decision and in the context of a new statutory instrument, namely the Care Planning, Placement and Case Review England Amendment Regulation 2021. That was a statutory instrument which amended the Care Planning, Placement, Case Review England Regulations of 2020, mouthful. The purpose of this secondary legislation is set out in the explanatory memorandum as being to prohibit placement of a child under the age of 16 in other arrangement settings with limited exceptions. The effect of the amendments will be that looked after children under 16 can no longer be placed in unregulated settings while continuing to allow other arrangement placements in alternative regulated settings by exemption. Unregulated, independent and semi-independent settings cannot meet the needs of looked after children under the age of 16 who are very vulnerable and often have complex needs which require the care and support provided by regulated settings. So that appears to close the loophole. This particular case concerned 4 local authorities: Tamside Metropolitan Borough Council, Derby City Council, London Borough of Lambeth and Manchester City Council. And 3 issues were raised. Firstly, does it remain lawful for the court to authorize deprivation of liberty for children under 16 in unregulated placements after changes to the regulations? In light of Re-T, the answer to this question was inevitably a yes. Mr. Justice McDonnell reminded himself that the Supreme Court had reiterated that, particularly in this context, such a power, namely the court's inherent jurisdiction, would be restricted only where Parliament had clearly intended it, and that there was no such legislative intent apparent from the 2021 statutory instrument. He was mindful of the fact that the statutory scheme was directed at regulating the powers of the local authority to place looked after children, and not the powers of the High Court under the inherent jurisdiction. In essence, the court was not the subject of the mandatory prohibition created by the amended statutory scheme. The fact that the local authority may be using an unlawful placement did not relieve the court of its positive operational duty under the ECHR to authorize a deprivation of liberty where required to avoid a real and immediate risk to harm, or to ensure that the child was not subject to torture or inhumane or degrading treatment. The second question before the court was whether the court's powers to authorize deprivation of liberty was limited to circumstances where there's no alternative regulated placement available, or if it's exercisable in all circumstances where authorization of deprivation of liberty in the unlawful placement is considered necessary to protect the child's welfare. To that, McDonald said this: whilst ordinarily it is likely to the absence of a regulated placement that will be said to constitute the condition of imperative necessity that informs the outcome of the best interest test, in circumstances where it will generally be the case that an available regulated placement will be better for a child than an unregulated placement, that is not to exclude the possibility of other conditions of imperative necessity that may justify the exercise of the inherent jurisdiction as being in the child's best interests in a given case. It is neither desirable nor appropriate to attempt a definitive list of what may constitute an imperative consideration of necessity. So no. The third question was whether a local authority retains the power to lawfully place a child in an unregistered children's home following the coming into force of the amended regulations, given its purported focus on unregulated rather than unregistered placements. The court, in fact, declined to address this issue, as it was not raised by the fact of the cases under consideration, and it required a wider examination of the statutory scheme than simply examination of the effects of the 2020 and 2021 regulations, which were the primary focus of the hearing. Moving on to a new topic, the 2021 decision of R is the recent decision on the issue of joinder in particular, but also in general, the role of the court in adoption cases where prospective adopters have been identified. The appellant foster carers with whom the child had been placed since the commencement of the proceedings made an application within the life of the care proceedings to adopt. The local authority, in the meantime, were championing the family members to potentially adopt the infant child. As the foster carer's application had not been validly made in that notice had not been given under Section 44, the learned judge took the view that the foster carers should be joined to the proceedings. The local authority appealed against this decision. The case, as I've said, also concerned the division of the responsibilities between the court and the local authority when it came to adoption in these very unique circumstances, where a placement order application was not being made without adopters being identified, but where there were two prospective adopters. The issue was whether the court should determine this as part of its final welfare decision, or if it should be left to the local authority as part of its statutory functions. On the issue of the joinder, the Court of Appeal found that the trial judge was wrong in both principle and law to join the foster carers as parties, since the exceptional circumstances did not exist. It reminded itself of the case laws on the issue of whether it's lawful or appropriate to join foster carers to care proceedings, and in particular the observation of Sir Mumby in the case of Ree T. 2015 decision, namely that from the very earliest days of the 1989 Act, the court has set its face against the joinder in care proceedings of foster care parents or prospective adopters. The Court of Appeal concluded that the case law is clear. save in exceptional circumstances, foster carers and prospective adopters should not be joined as parties to care proceedings. And this is notwithstanding the fact that by the date of the appeal, the foster carers were entitled to apply for an adoption order by virtue of the fact that the child had lived with them for a year. And in those circumstances, their application to adopt would have had to have been considered before any final decision was made about the child's future. While the court acknowledged that the foster carers had by then made an application to adopt, that application only arises for consideration once the court had decided in principle that he should be adopted. The court concluded that the right course of action was for the judge to list the local authority's application for a care order for final hearing. At that point, the court could have considered if adoption in principle was the right option. In the event that the court determined that adoption was the right option, it could have made the care order and then proceeded to consider the foster carer's application alongside the local authority's application for a placement order. And almost as if we'd planned this, it's almost 6 o'clock. But before we conclude, Suzanne and I just wanted to bring to your attention the case of NHL, a 2019 Court of Appeal decision, partially because it's something which has impacted both of us fairly recently. It's a case about participation of parents who are discovered during the course of proceedings to have cognitive difficulties. And very briefly, it was a decision from our Judge Ray's side, in which during the course of the mother giving evidence, it seemed that the mother had difficulties. And what the Court of Appeals said should have happened is once the judge had concerns, she should have stopped the proceedings at that point and gone down the route of ordering cognitive assessments and intermediary assessments, etc. When we send these notes out, I'll just have the citation for that case for you to look at. But thank you very much for coming today. As I've said, the notes will be sent out in due course. I hope you find it useful.